Welcome to US Litigation Now. My name is Akira Inoue, a partner at the Baker & McKenzie Tokyo office. Today, we welcome Mark Goodman from San Francisco and Jennifer Semko from Washington, DC. Both of them have over 30 years experience in US litigation. And today, we will be dealing with document retention policy. And to start with, I have a couple of questions to both Mark and Jennifer. And the first question is why document retention period and policy is important. Legally speaking, can company delete, discard document whatever and whenever they would like? Jennifer and Mark, would you give us some insight on this question?
Sure, Akira. I will handle the question about why it's important for companies to have these policies. So for any company doing business in the US or having relationships with companies that do business in the US, it's really important to have document retention policies and good practices for retaining documents and managing documents. As our loyal viewers know, there are broad discovery rights in litigation in the US, meaning that parties are entitled to produce and receive documents from the other side and to the other side for long periods of time and for lots of different types of documents. So it's really important for companies to have an ability to recover those documents and to produce them in that litigation. Courts in the United States generally have very strict requirements and broad expectations about how long companies will retain documents and be able to produce documents. So that's another reason that it's important to have these practices and procedures that we're going to talk about today. And if you're even if you're not going to be getting documents from the other side, sometimes it's really important to have documents from your side that are important to help prove your case in litigation in the United States. So without a really comprehensive document retention policy and one that's in writing so that everybody in your company understands it and you can show that you have these document retention policies to a court, then you can result in penalties that a court can impose that we'll talk about later.
Thank you, Mark. The next question is, why too short document retention period would be problematic from U.S. litigation standpoint?
So I'll take that one. As Mark mentioned, U.S. courts have a pretty high expectation of a company when it comes to preserving documents relevant to a dispute. And U.S. companies have been living with those very high expectations for decades. And U.S. companies are also very familiar with the broad discovery that we in the U.S. have to live with. But for companies outside the United States, this type of discovery can be unfamiliar. And companies outside of the U.S. can also be unfamiliar with the expectations of U.S. courts. But at the same time, companies these days are dealing with tremendous volumes of data, electronic data, emails, instant messages. And so because of that, Mark and I have seen a number of situations in which U.S. companies have, for business reasons, adopted pretty aggressive document destruction timelines, but those aggressive policies don't always match up with what companies in the U.S. are doing or with what U.S. courts expect. Although our courts in the U.S. don't really mandate a specific document retention period, which we'll talk about in a minute, our courts are very clear that documents have to be preserved when a dispute arises. So, to your question, if your company has a retention period that is too short, that can be a real problem for a number of reasons. First, it can make it even harder to assemble the documents you need to prove your case, and Mark touched on that a moment ago. And second, if you have aggressive document deletion policies, you're more likely to inadvertently breach your obligation to preserve documents. For example, if emails are deleted very rapidly and you wait just a little bit too long to preserve documents in litigation, you may lose important documents very quickly. And lastly, it can be a problem if your aggressive timeline doesn't match up with the U.S. judge's expectations. A lot of U.S. judges really aren't used to some of the really aggressive document destruction policies we see outside of the U.S. And so when documents are lost, the judge may be fairly skeptical that your company took enough sufficient efforts to preserve those documents.
Thank you, Jennifer. Speaking of breaching obligation and also not being able to meet expectation by U.S. judge, if that should happen, what legal risks a company will face in U.S. litigation, especially in a case where the document retention period is regarded as too short? What should happen?
Yeah, Kira. So it's pretty much what Jennifer just went over in what she just said. If documents are inadvertently destroyed, or if the company's policies have a too short of a destruction period, then that can be a problem if evidence is destroyed in litigation. And usually that shows up in a fight over what's called spoliation of evidence, where one side says to the other side, you destroyed evidence that I should have had in litigation. It would have been important to me. And they go to the court, and the court will find if there is spoliation, then there can be a whole litany of remedies that the affected party would have. One is to get the most draconian remedies to get absolute dismissal of the claim. So if you're a defendant and the plaintiff spoils evidence, you can get the plaintiff's claim dismissed. If you're a plaintiff and the defendant has spoiled evidence, you can get a judgment entered against the defendant. Or a court may issue adverse inferences so that there would be instructions to the jury that the jury is to assume that all the information that was destroyed was bad for the party who destroyed it. And therefore, evidence, the jury or the court has to assume that evidence would have been in favor of the other party. That can be a really important inference in litigation. There can also be monetary sanctions issued where a court can penalize the party that destroyed the documents with monetary sanctions that can range from tens to hundreds of thousands of dollars. Sometimes in litigation, we've even seen millions of dollars in sanctions for evidentiary issues like what we're talking about right here. And you can also have courts order the other side, the party that destroyed the documents, to reconstruct all the evidence, which of course can be extremely expensive and time consuming. So there's a whole list of things that could happen, Kira, if there is a determination that there has been spoliation, which is why this is so important for our friends.
Thank you, Mark, for sharing quite important insight. And speaking of the actual risks, you kindly laid out like a dismissal of the case, adverse influences, and penalize monetary penalty and reconstruction of evidence. Do you happen to know the actual case where those the risks have been realized in actual case? Do you happen to know the real case?
Sure. So the length of a party's document retention period has been a factor in a number of cases. As I mentioned a minute ago, courts don't really impose an absolute rule about how long documents need to be retained, but it's often a factor, not the only factor, but a factor when the court is considering what to do when documents are lost. And I'll give you one example that comes from a federal court in the state of Maryland. That defendant had an email retention period of 21 days, which by U.S. standards is pretty rare. And the judge noted that, and he called that period extraordinary. But he went on to say that, look, this is very risky, having such a short period, but in some circumstances, I could see this being a defensible business practice. But then he went on to point out that this company not only had a short retention period, but when the litigation arose, they took months before they stopped the deletion of emails and before they issued a litigation hold notice to their employees. So taking all of those factors into account, the judge imposed pretty significant sanctions, including an adverse instruction to the jury. There is another case coming out of California in which a party got sanctioned for a number of reasons, but among the reasons the court considered was the fact that that defendant had a 90-day email retention policy, but just before the litigation changed to a 30-day retention policy. And the judge was not convinced that the reasons for that change were legitimate. And the judge, based on certain witness testimony, because the defendant's employees were grilled about this change, the judge concluded that part of the reason the change was made was to try to avoid hanging on to documents that would have to be produced in litigation. And that judge imposed some monetary sanctions. Mark and I have also litigated cases where the judge has looked unfavorably on very short document retention periods. And as I mentioned before, when you have these short periods, it makes it more likely that you're going to be at risk of deleting documents. So at the end of the day, it's not the only consideration, but it will be a consideration for U.S. judges.
Thank you, Jennifer, for sharing the actual case and also the actual example of how long the document period of those cases have been. And given those cases in front of us, any recommendation for appropriate document retention period for listeners of this video?
So, Akira, as Jennifer just said, there is no bright line rule, and she's 100% correct when she says that it really depends on the circumstances. I think a general rule is longer is better, so that it's rare that if you have a document retention policy for a number of years, that a court will find that to be insufficient. If you can't retain documents for that long, then as Jennifer said, you really need to have a good business reason for having a shorter document retention policy and a document destruction policy that you can support in court. Perhaps the most important thing to keep in mind, as Jennifer also alluded to in her real case examples, is once there is an indication that you might be having a dispute with somebody, immediately stop your document destruction, no matter what your policy is. So if you feel like there might be a dispute coming, it's very important to stop document destruction entirely right away, so that you preserve all those documents. That's the best way to really protect yourself in U.S. litigation from these types of spoliation sanctions that Jennifer and I talked about today.
Thank you, Mark, for sharing the excellent and deep practical insight. quite insightful to many listeners from Japan. And we will continue this discussion, and please stay tuned with Beck and McKenzie Litigation Now, and more to come. And thank you for listening.